So I will now open a hearing on appeal of a notice of violation in Clatsop County violation file number 186-24-000056 NVST. There are two different properties involved under that file number. And so I can be convinced otherwise, but I think what I'm going to do is treat this as two hearings. The first one being for the Smith property, followed by a hearing for Wygant, if I'm pronouncing that correctly. And the reason is because I need to write a written decision, and from what I've seen so far in the record, it looks like there are a couple of different arguments being made by the two different property owners. And I want to separate those in two different decisions so that if they choose to pursue an appeal, they aren't tied together in one decision. I see Ms. Henriksen has her hand up, so please give me your feedback on that.
Yeah, I think, Nancy, correct me if I'm wrong, but we are not hearing the Surf Pine sign cases today. Is that correct? I thought this was a different case.
That is correct. That the Wiggin and Smith got canceled. This is for the Owen Hansmeyer. I provided the exhibits for this hearing on June 3rd or June 4th via email.
Okay, give me 1 second here then.
Sure.
Well, then in that case, I'm looking in my email and I'm not seeing the exhibits on my end right now.
Okay.
I can take a break here to look a little more closely.
It was the email was sent on Friday the 6th.
Okay, I did
June
see a
6th.
June 6th email. Let me check that one real quick. Okay, I see the exhibits from June 6th. So let me just update my script here. It will take me 2 minutes and then we can get started, and I apologize for the clunky beginning here. 1 second. Okay, thank you everyone for your patience. So I will now open a hearing on notice of violation in Clatsop County file number 186-24-000066. Today's date is Wednesday, June 11th, 2025. The time is 10:05 a.m. My name is Rebecca Dorman, and I will be acting as the hearings officer in this case. I have a few things to state for the record before we get into the substance of the issues. So please bear with me here. Okay, first, I will provide hearings officer services to the county in this appeal. I do that through a contract with the county. I'm acting as an independent and impartial decision maker. I have no financial stake in the outcome of this, and I have no bias one way or the other. I have not received any ex parte communication outside of this hearing about this case, with the exception of, as we just were discussing in email, with the exhibits, which all parties should have access to, and logistics of getting the hearing scheduled. So with that said, I'm going to give anyone an opportunity to challenge my qualifications to hear the matter or to act as the hearings officer in this case today. Okay, hearing none, then in this case, the county will have the burden of proving that the alleged violation exists by preponderance of the evidence. The rules of evidence don't apply in this case, in this kind of case, and the kind of evidence that we're going to be relying on will be the kind of evidence that responsible persons are accustomed to relying on in their conduct of serious affairs. Although some evidence may be relevant, if it's not helpful to proving one way or the other the existence of the violation, then I may determine that it's irrelevant and not necessary for deciding the case. So the testimony and evidence must all be truthful, and so to ensure that everyone is taking that seriously, I will ask that we all affirm that the testimony that we provide today is the truth, and I will do an affirmation with anyone who will be providing testimony when it's their turn to do so. And when it is your turn to provide testimony, please state your name and address for the record. As for the procedure for today's hearing, first I will ask county staff to go through the exhibits that are in the file and provide a narrative overview of the case and the history. Then I will ask the appellant to provide their presentation, their testimony, and any evidence that they may have to introduce into the record. And finally, I'll ask the county to respond to anything that's been heard at that point. I may be asking questions along the way. I will be issuing a decision within 14 days of the close of the record or the end of today's hearing, whichever occurs first. My decision will be the final county decision on this matter, and it would be appealable then to Clatsop County Circuit Court. Are there any questions about the procedures before we begin?
Nope.
None.
Okay, great. Then I'm going to ask Ms. Mendoza to please walk us through the county's exhibits and give a little presentation narrative history on what is happening.
Did I need to testify?
Yes, I think let's go ahead and do that. We'll just go ahead and
Okay.
give that example for later. So after I make this statement, please state yes or no if you can affirm that the testimony you're about to provide is the truth, nothing but the truth.
Yes.
Thank you. You may proceed.
Thank you. There's a couple things that I need to talk about before I present or ask about before I present the narrative. The county did not receive a written request to reschedule the hearing within 2 days from the responsible party. And it also did not receive a written statement in lieu of appearance from the responsible party or on behalf of the responsible party. So the individuals that are here, being Ashley Wynn and John Owen, are not listed as the responsible parties, but are wanting to represent the property at 89740 Highway 101. And so I spoke with Ashley Wynn yesterday about this, and I think that she has something that she would like to say or ask before we proceed, if she can, concerning why she's here representing John Owen.
Okay, and so Ms. Mendoza, you would like for us to talk about that before we get into any further into this? Okay, and I know that the county's code gives some direction when the responsible person does not appear at a hearing. So what I'm gathering is that the responsible person is not here with us right now.
That's correct.
Yeah. And then let's give me a minute here to get into the Clatsop County Code to refresh my memory on what we need to do in that case.
It is Clatsop County Code 1.14.090. And then 1.14.100 that speaks of the responsible parties, a responsibility of providing a statement.
Okay, so I'm seeing that the responsible party may request that the hearing be rescheduled. And that must be provided in writing and delivered to the county. I'm hearing that no such request has been made.
Not in writing, no.
Okay, and that must be made within 2 business days before the hearing, 2 days before the hearing. Okay. Okay, so we don't have all the ingredients then to reschedule the hearing.
Correct.
And there's no directive in there on when there's extenuating circumstances, because we had every intent of trying to get ready for this hearing, and it was a emergency health issue that came up yesterday. It's the reason why I called last minute, because we were expecting a short day surgery on a simple hernia operation, and that John would be able to come and testify today. And it ended up being a major surgery, because he had multiple hernias, and they were called incarcerated hernias, which are way worse. And so he did not get out of surgery for 4.5 hours. And so he is heavily under the influence of muscle relaxers and narcotics today. And so knowing that, yesterday I called to try to see if we could reschedule it, knowing he would not be competent enough per Oregon State Code 40.310 to testify under oath. So he's trying to stay in compliance and be in compliance, but it was a medical emergency that has now made it so even if he testified today, it still would, and he lost, I think it would be appealable, because he is not competent right now. Plus, we also we got like 3 days notice to get ready for this hearing. And I think state says that we have to have a minimum of 7, and we had 3, because we were notified by personal service on Thursday the 5th. And John notified Nancy and told her that he had surgery coming up. And so that surgery was yesterday. So that gave him technically 2 business days to get ready for this hearing. And he was dealing with major, his gut's outside of his body. So I think on 2 grounds, the competency of him being able to testify and the fact that we did not receive proper notice to get ready, we shouldn't be having this hearing today. But
Thank you. Is it Miss Wynn or Mrs.
Ye-
Wynn?
It's Miss Wynn.
Miss Wynn, thank you for that information. I will ask you, what is your relationship to the responsible party? Do you have?
He's my fiance. We've
Okay.
been engaged for a long time.
Understood. Just for that record, that connection.
I just got side-eyed. So he is awake. So he's here. He could probably try talking to you if you need be, but
Well, then, I'm gonna go back to Ms. Mendoza. Can you talk about the notice of the hearing? I heard Ms. Wynn challenge whether that was provided according to the code.
Sure, the notice of violation, um, uh, let me start over. The hearing procedures, notice of violation was mailed on June 3rd. In our code, we have to give 7 days from the mailing for it to be acceptable period of time. So it was certified mailed on June 3rd. And it was received, I don't know when it was received. I think it was
June 5th.
okay. By certified mail, it was
yeah.
received.
Okay. Yes, so I know that I'll just say this kind of generically, that when we are in these kinds of situations, usually there are multiple steps along the way of notices provided by the county. It sounds like you know, something that was planned to be, you know, a nominal procedure turned out to be less than nominal, and I think that that's kind of a unforeseen circumstances, the way I would categorize that. And to proceed today with that, I think that would potentially prejudice the responsible party's ability to fully participate. And so just to kind of make a better record and have full participation, can we talk about a new hearing date for this matter? In other words, to reschedule.
Yes, the county is willing to discuss that. But if I could get further clarification with the county considers the responsible party to be Marie Hansmeyer Owen, who is the property owner. And because we didn't receive notification from the responsible party, are we still able to move forward as Mr. Owen or Ms. Wynn representing the responsible party?
Yeah, so that's a good question. So thank you for bringing that up. So we know Ashley or Miss Wynn's relationship to John Owen, but what is the relationship to the responsible party then, Marie?
It would be future daughter-in-law. I'm here helping him because she needs 24/7 care. She has 2 strokes, and so she cannot take care of herself at all. She requires 24/7 care. So John actually is her primary care person. We've had other court hearings with probate and things like that where he's been identified as her mouthpiece, I guess, for lack of a better word. She's here in the house with us, but she's even worse than John. You know, she will tell you her name and be able to tell you probably her address, and that's about it. She does not understand what's going on here at all. So if there's something legally that we need to file to make John the responsible party for a future hearing, we will be happy to do that. But he's not on the title. So technically she is the only responsible party and she is not competent at all. She's got severe dementia, stroke, incapacitated.
Um. So for these kinds of proceedings, usually when there's, you know, severe, medical reasons why a responsible party, can't represent themselves, then there usually is some kind of a legal, documentation to, give authority to someone else to act on behalf of the responsible party. It sounds like we may not have that information here, which is a little bit complicated. I think that I would be inclined to give Mr. Owen and Ms. Nguyen the opportunity to bring that information in a future rescheduled hearing based on the information they've provided today. I think that would be the most fair way to move forward as far as you know, what I'm hearing today about the situation that they're in.
We would appreciate that very much. And there, I know that John's been talking to somebody about a power of attorney, just so it, because this keeps coming up. And then, you know, we spend the court's time trying to explain why we're in the situation we are. So there is motion to get a power of attorney. We just haven't been able to do it because of his health. So we're close, but he's trying to do everything he can to be in compliance here. So if we could just reset it even a week out, it would help us a lot.
Okay, Ms. Mendoza, what is the county's position on that, giving them a week to provide that kind of paper trail of authority?
The county's position was to move forward with the hearing today, but since John and Ashley are allowed to represent the responsible party, I think that it's fair to allow them to get the paperwork, what they need to get together for a hearing at a later date.
Okay. Then, you know, today we're at Wednesday, June 11th. And a week from today would be Wednesday, June 18th. Is that a doable timeline for Ms. Nguyen? And, you know, in these kinds of cases, obviously the community is interested in resolving the compliance issue. And so time really is of the essence in being able to move forward with this proceeding.
I just looked at his discharge paperwork, and the next Wednesday is his follow-up appointment. It's in the morning. So, you know, we could do it either in the afternoon on that day or maybe the next day. It just happens that it says that he has an appointment at 8:15.
On the 18th, I'm sorry, Ms. Nguyen, did you say that that's 8:15 on the 18th?
Yes.
Okay. Well, then the 19th is a holiday, I believe. Does the county generally hold these kinds of hearings, the code compliance hearings on Wednesdays, or are there other days that work for the county?
We are very flexible on the days that we can hold hearings and time as well. There are some constraints with meetings, but generally we're very flexible.
Okay. Would Mr. Owen be back from his appointment by 10 a.m. on the 18th?
That might be pushing it because he's got to go. Yeah, that would be tight. Because if they didn't see us right away, we probably wouldn't.
Okay. So it sounds like maybe the 20th, Friday the 20th is a better day than if that's workable for the county.
Unfortunately, that does not work.
Okay,
See if I have something.
okay. I'm looking at Tuesday, the 24th of June. Does that happen to be an option?
Without looking at my calendar, I believe that's fine. I would have to verify with my supervisor and our permit technician who actually runs the hearing that they're available as well. But I
Okay,
think that's okay.
could we go ahead and do that just so we don't have to renotice the hearing? We can continue it, I think, from here without having to concern ourselves with a renotice.
Okay. I do have a question also. There was the hearing packet that I sent out to you and also provided to John Owen. I mailed the hearing procedures, the notice of violation, and that was received via certified mail. I, however, did not include that in the hearing packet. Can I provide that prior to this next hearing?
Yes, I would say we would continue the hearing and keep the record open
Okay,
for that period of time.
okay, thank you.
So that means we can still send, I can get you pictures on our end, since the record will be still open.
Yes, yes. You will have a chance to provide evidence either at the hearing or in advance. Ms. Mendoza, please clarify if they should send that in to you or to me directly.
I have on the hearing procedure, the notice of violation, I asked that they send all correspondences to the to Clatsop County Community Development with the address there. So I also provide an email as well that is acceptable for any evidence they may have.
Okay,
So then it sounds like we just need to decide, we'll find out if Ms. Henriksen and is it Ms. Matthews?
Yes.
They're available to assist with the hearing on June 24th and then a time from then.
Yes, I would be available anytime on the 24th except 2 to 3 p.m.
And I would also be available anytime on the 24th.
Thank you both. I think I would be inclined to do a kind of an odd time, but 11:30 on that day.
That would,
that would work for us.
yep,
That work for everyone? 11:30 on June 24th.
yes.
I think then the only thing that we would need to clarify is if the same Zoom link will work, or if the county will be emailing a new Zoom link for this hearing, the continued hearing.
It will likely be a new Zoom link for the continued hearing, yes.
Okay, thank you, Ms. Matthews. And do you know approximately when Ms. Nguyen and Mr. Owen should look for an email with that new link?
I can send it out this afternoon.
Okay,
We do not have an email for either Miss Nguyen or Mr. Owen.
I can give you that.
Okay,
then I'll let you do that outside of the hearing if that works.
Okay. Nancy, do you want me just to call your office and give it to you?
that would be just fine, yes.
Okay,
Okay, then we have determined that we will reschedule this hearing, consider it a continued hearing. The record will remain open. The date and time certain will be June 24th, a Tuesday at 11:30 a.m. Ms. Nguyen will be in communication with Ms. Mendoza on how to provide the link for the continued hearing.
that sounds good.
Okay, are there any questions before we close the hearing for today?
I do not have any.
We don't either. Thank you very much for your consideration.
Thank you, everyone. Have a good day. Thanks for your
Thank
time.
you. Thank you.
Oops.